Hello everybody. Most property professionals are familiar with ground F of section 31 of the Landlord and Tenant Act 1954, the ground that enables a landlord to oppose a business tenant's application for renewal of its lease on the basis that the landlord intends to redevelop the premises. Less familiar are the first three grounds for opposing renewal under that section of the Act, what are known as the tenant fault grounds. There's ground A, the tenant ought not to be granted a new tenancy in view of the state of repair of the holding, being a state resulting from the tenant's failure to comply with its lease repairing obligations. Ground B, the tenant ought not to be granted a new tenancy in view of its persistent delay in paying rent, which has become due. And ground C, the tenant ought not to be granted a new tenancy in view of other substantial breaches by him of his obligations under the current tenancy, or for any other reason connected with the tenant's use and management of the holding. Now note in each of those cases the words ought not. They mean that where any of those three grounds has arisen, it's at the discretion of the court as to whether the tenant ought to be granted a new tenancy. Now, the Court of Appeal has just offered some guidance on how those tenant fault grounds should be interpreted in the case of Gill and Lee's News from 2023. The tenant Lee's News requested a new lease of its newsagent shop and convenience store in West London, which had security of tenure under the 1954 Act. The landlord, Mr. Gill, responded with a notice stating that it opposed the grant of a new lease on those tenant fault grounds in the Act, namely the tenant's breach of its repair and other obligations in the lease and persistent delay in paying rent. And the landlord argued that those breaches meant that the tenant ought not to be granted a renewal lease. When the case went to the High Court, the situation had been that while the store was in substantial disrepair, ground A, at the date of the landlord's Section 25 notice, the defects had been remedied by the date of the court hearing, and the other breaches, late payment of rent, ground B, and breaches of other lease covenants, ground C, were minor breaches. So the High Court ordered a new tenancy to be granted for the tenant. The landlord appealed, and the Court of Appeal examined two main issues. Firstly, what was the key date for assessing the tenant's breach of the tenant fault ground? And how should the phrase in the statute, the tenant ought not to be granted a new tenancy, be interpreted? On the question of the key date, the tenant argued, as it had successfully before the High Court decision, that the date of the hearing was the key date for establishing whether it was in breach of its obligations. It argued that any earlier disrepair was irrelevant as it had remedied the defects by the court hearing date. The court, however, agreed with the landlord's approach that assessing the breach was not tied to a single snapshot on the date of the hearing, and in deciding whether or not a new lease could or could not be granted, the court could look at the tenant's compliance with its obligations throughout the term of the lease. The fact that the tenant had carried out repair works between the date of the notice and the hearing was relevant. However, the court made it clear that carrying out the repair works would not necessarily entitle a tenant to a new lease. If the tenant has a lamentable record of performance, in the court's words, but puts things right at the last minute, that could be taken into account in refusing to grant a new lease. On the question of how the court should exercise its discretion on whether a new lease ought not to be granted, the appeal judges emphasised that it was not limited to considering each ground in isolation and could look at all the grounds cumulatively. and the appeal judges held that there are many factors which could potentially be relevant, and that's perhaps the biggest takeaway from the judgment. Now, in Gill and Lee's news, the landlord lost its appeal. The court took into account the fact that the landlord had been a hands-off commercial landlord during the term of the lease and had not enforced the lease terms against the tenant during the term. But it also gave weight to the fact that the tenant would lose its livelihood if it wasn't granted a new lease of the shop. And the court concluded that the tenant had learnt its lesson, and the threat to its livelihood would be a strong incentive on the tenant to comply with its obligations to repair and to pay rent on time in the future, and so it did grant the tenant a new lease. Now, although the judgment was in favour of the tenant, it was very much based on the court's confidence that the tenant would comply with its obligations in the future. The case clarified that where there are multiple grounds of opposition under Section 30 from the landlord, the court will take a wide-ranging approach and will consider the full range of the circumstances. So, to conclude, a tenant cannot repeatedly breach the terms of the lease and expect a new lease merely by paying off arrears or making good repair or other breaches just before a lease renewal hearing. And secondly, landlords have some assurance that where there are multiple grounds of opposition, such as disrepair, non-payment of rent and breach of other lease obligations, the court will consider all of them in the round in deciding whether to exercise its discretion not to order the grant of a new lease. That's all from me today. I may see some of you at our property conference in 2 weeks' time. If I don't, I'll be back with another vlog in a fortnight. See you then.